giving me the thumbs up.
Is, Jeff gonna be?
Angela, have you heard from Jeff? Have you heard from Jeff?
Not today, I haven't.
Not
He
today.
accepted the meeting.
Yay, you're here.
If you guys want to come up to the table, I would appreciate that more. Is that okay? Yeah. Because you're going to have to get up and get in the microphone, talk in the microphone. So we'll leave a spot for Jeff if he comes, but, and then there's one over here.
I can move to grouping people.
Stay with the group, maybe.
I don't, it doesn't matter. Just leave a spot for Jeff.
Lisa Robertson's coming.
I'm not sure about Lisa. I know Chuck will be here shortly.
I
Okay.
can scoot up next to Elaine if you're,
It's up to you.
well, however you want to group your.
I just want to make sure everybody's by a microphone and we're not jumping up and down, unless you guys want to jump up and down. Okay. I'd like to call the meeting to order. Good afternoon, and welcome to the Public Health and Safety Committee for September the 1st. And first thing we'll do is call the meeting to order. We've done that. Approval of the July minutes.
So moved.
So move. It's been moved and seconded. All those in favor, raise your right hand. It's 2-0. Okay. And next, we'll continue to talk about the ordinance. Luther, I don't know if you want to start us off, or you want, we didn't hear, if we could, can we hear from Ms. Pinkley, right?
Yes, Lisa
Okay.
Pinkley.
If we, did you have some questions for her, Karen?
Testing.
I do. If
Okay.
she's got plans to present comments, that's fine.
Well, let's start off there, and maybe Jeff will come in, and, is that okay with everybody? We'll start there. Let's do that. Is that okay?
Sure, I don't really have any comments. I was waiting to hear from you folks to see if you would like for me to comment on an issue.
Well, Karen has some concerns, I know, so if you want to go ahead and ask her whatever concerns you have, and then
Okay.
we'll start there.
Well, I would start. Have you had a chance to read through the proposed changes?
Yes, ma'am, I have.
Okay. Overall, there is the changes retain the discretion on the part of the animal control officers on whether to pick up an animal immediately after the incident, and in fact, whether to pick them up at all, as I read it. They do provide the opportunity for a choice for the city to order euthanization on the first offense. And then we also did some fine tuning on the exceptions. So I have another question after that, but in particular, in your view, how has it been working so far? And will these proposed amendments work, in your opinion?
Yes, ma'am, having it be our discretion has worked very well on our behalf, because we feel that some dogs that may just nip somebody may not be picked up and impounded. It just depends on the circumstance and the extent to the injuries that the dog did on the victim or the victim dog.
There are some people, of course, who have been vocal, who have wanted them all picked up and all euthanized if they just drew blood. And so I was very eager to hear your reactions on how it's gone before, because it's different whether you pick them up or not if they just nipped somebody, or whether they almost killed another animal or a human being. And there have been some incidents, and I'm not saying right or wrong, where there's been a pretty serious damage inflicted by the aggressor dog, and the dog has not been picked up, at least not immediately. And so,
In that instance, though, it should have been.
because there was the one in Oakland where the dog was next door and the 9-year-old child, which we've heard a lot about.
Yes, I remember that one.
And then there was also the one recently in Kenwood where the dog came and just about killed another dog in its front yard.
Yes, and those type of dogs should be picked up and impounded on a dangerous dog charge and held until court.
Okay. I don't know why the one in Oakland wasn't picked up.
Because the owner wasn't home to allow us to take the dog. That's why it took so long to get it picked up and impounded.
Okay. And then the other one, the word was that back to the owner, that the officer at the time told her it would be up to her whether it happened. And also later they said, well, people had followed the dog home. The dog went home. So they knew where it lived, and the owners were there and said they didn't know it was out. But the discussion, which I wasn't familiar with, but I understood that the theory was, well, because the damage was so bad and you're going to have really big vet bills, if this family, if we leave the dog for a little bit and the family helps with the vet bills, that could help you out, could help the whole situation out.
They may drop the dangerous dog charge if they help with the vet bills. I think that was what they were trying to get across there.
Well, yet at the same time, that dog had just about killed that other dog. It had tasted blood, if you will. So part of the dilemma, I would think, with us setting this policy is, is that strategy one that's safe for future humans and dogs?
To pay the vet bills?
Well, I understood the strategy of helping the vet bills get paid, for sure.
I understand that too, but a lot of people won't pay the vet bills. They say they will and they won't.
Understood. And in this case, they
And-
did.
Yeah, and then
actually.
after they don't pay the vet bills, then we hear from the victim, they want to sign a dangerous dog complaint after they know that the vet bills aren't going to be paid.
And the issue would be just who drives that decision, if that's supposed to be the
Yes.
professional decision.
Yes, we could just go right on in there and say, we're taking the dog, we have to impound it, or you can take it to your own vet and impound it at your expense.
Right.
And it has to be a vet within the city limits.
I just remember when we worked on it before, that issue of giving the discretion to the ACOs was quite an issue at the time, and it did seem to have worked out.
It worked out well for us, giving us the discretion.
And again, maybe people would have made different calls in those two cases that I just mentioned, but if if that discretion is working, I want the committee to hear that, and I wanted to hear what you thought.
And we go by what the victim wants too. If they don't want to press charges, it depends on the extent of the injuries. And if a dog mauls somebody, they're not going to get a discretion on something like that. We're going to impound the dog for other people's safety.
Well, because there are a lot of animal lovers, and I have since, as we talked about that, heard people tell stories of the family dog. And maybe everybody in the family brought their dogs at Christmas, and all these these dogs were well behaved, but all of a sudden they were all in the same house and bad things happened. Or, in the case of this gal whose dog was mauled, she's an animal lover, so to leave it up to her, it probably wouldn't have happened, but people really had a lot of second thoughts. The owners of that dog said that they were just going to move to Colorado. And it was like, well, do we have some liability if we didn't do anything and then they take that dog to Colorado and it bites somebody?
Yeah, and most time they don't move to Colorado. They're just saying that.
Well,
So
I
we have to
understand
take that
that.
in consideration too. They're just trying to get out of the ticket sometimes when they say things like that.
Okay, well, to sum up then, you did think it's been going okay with that discretion.
Well, yes.
You're comfortable with adding in the option to euthanize on a first offense?
Yes.
Okay.
If
But
warranted, yes.
if warranted.
yes.
So the discussion that the committee had before about whether it should be automatic or mandatory versus optional, the
Right.
option
The optional.
is better? I
I-
don't want to lead you too
I
much. I'm
believe.
just checking.
I
Okay.
believe that, yes, because it could warrant it the first time, depending upon the extent of the injuries.
Thank you. Then I wanted to ask you also about the fees. The proposal that staff provided was to make the fees non-negotiable so that they were a little more standard in court, as I think they explained it. But they also raised the fees. And my recollection from the past, similar to the discussion about the vet bills, was that we had debated that before and left them a little bit lower so that there was money for the court costs, the vet bills, and so that ideally the owners would get the dog back instead of leave it at helping hands as well. So have you had a chance to look over the proposed new fees?
I believe it indicated $499, if I remember right.
$499 to $1,000
Yes.
on some, and then $250 on others?
On 250, I believe, was for the dog, attack on another dog.
I think that's
Did I
right.
read that right? Okay.
Mm-hmm. All the way, let's see. First offense on another dog, yeah, it would knock it back. Instead of being 1 to 499, it would be 250, no matter what the circumstances were. And the second offense as well for on another animal. But then it goes, instead of being 1 to 499, if there's an attack on a human, it goes, it instead is 499 to 1,000.
Yes.
What-
That used to be 250 a long time ago. I don't know if that makes any difference.
Well,
Yeah.
your feedback from your experience with the cases, because this isn't just what happens in court, it's
Right.
what does that family do? Do they help with the vet bills? Do they take their dog back? What you thought as a much more, rather than a legal matter per se, a strategic matter, in terms of what would be a good figure, so that,
I think that would be a good figure, 499 to 1,000.
so
for
going
hu-
ahead and
for a human
raising it,
attack.
doubling it?
Yes. Yes.
Okay. I will have a question later for whoever would know it, and if you know it, that's fine, in terms of what we're doing, how we're doing on collections of those very fees now. Maybe the court has that. So we don't have to switch gears, but, you know, for us to double a fine, if we're not even collecting it at the level that it is, I wanted us to check it. One last question for,
If I may interject here, though, Karen, I think that's sending a loud message that we're not gonna tolerate people that are not gonna be responsible for their dogs.
I
think that's sending a clear message. You know, we've got a lot of dogs out there that are running loose. I've been getting so many calls and so many emails. And to keep the fine, I mean, whether they're paying it or not, they're gonna second guess it once we pay this. Either they're gonna be responsible or they're not, or they're gonna get those fines a couple of times and they're gonna get serious. That's how I look at it. So I guess I don't have a problem with doubling it. I think we do like anything else, and Judge, if you wanna chime in on this, we do our best to collect our fines, but you know, people are gonna do what they wanna do. Either they're gonna pay it or they're not. They have an option to make a payment plan, but they also have an option to make sure that their dog is safe.
right, part of the discussion in the past, and I know that Officer Pinkley especially has followed these cases here in Topeka for a long time, was, the city was bearing the expense of holding the dog at
Right.
Helping Hands and a certain statutory period of time as well. And the frustration, I don't think they got invited to the table, but of seeing a dog just sit if the owner wasn't gonna come pick it up. And if the accumulation of all those dollars was making a difference in whether owners went back and picked up their dogs, it was just something for the committee to know as we considered, I felt.
I
Not
think,
taking a position necessarily, just knowing whether it makes a difference. Because that decision they made, for instance, on the Kenwood dog earlier, of not to pick up the dog right away as a strategy to get the owner to pay the bills, did work, because they were aware of how people make decisions in these cases. And so I just wanted to hear what she thought.
The only problem with that is then they're not brought up on dangerous dog charges, and the dog could get loose again and bite somebody, and then there won't be any documentation in court of a first offense or a first
Exactly.
conviction of dangerous dog.
true.
Well, and that's why I asked the question about the officers, using the discretion, but if the fact that the officers in their head know that there's going to be really big fees and other costs, I wouldn't want us to set the dollars so high that the discretion got used inappropriately about picking up a dog,
Right,
because you guys have that discretion in your hand.
right.
So I just wanted to raise, because you're making the call. And the lawyers in the court never see that case if your people don't pick them up.
Right. It depends
So-
on the extent of the injuries also, if we bargain with people like that. If we say, okay, well, we want you to be able to have the money to pay the vet bills, so we'll just maybe charge you with dog at large. for instance, the dog was loose, so we'll just charge them with dog at large and not dangerous dog. That way they won't have to pay the high fine, they can have the money to pay for her vet bills, something like that.
Just want the committee to be
If that's-
aware that they've got that discretion and they're using it. So we don't necessarily have the numbers of tickets even for dangerous dog, for dogs that have hurt other dogs and animals, or other animals and people at this point.
What was staff's reasoning for doubling the fine?
One thing I want to be clear on is the proposal of $499 to $1,000 is for an attack on a human being.
Okay.
The $250 fine is for an attack on a dog. If you look at the definition of dangerous dog, there are two other ways a dog can be deemed dangerous, and that is a known propensity to attack, or if the dog approaches somebody in a vicious, threatening manner in an apparent attack. And so then the standard code penalties would apply in that situation. So a dangerous dog that just approaches somebody, growling, barking, that sort of thing, then the range of penalties is just like any other violation of our code, $1 to $499. But if there's an actual attack, we want that to be treated differently, and we want it to be treated differently consistently.
And that's where the numbers came, the
Right.
new figures came in. Okay.
And that's why we did that, because we want to be consistent in the penalties, and we want the penalties to escalate based on the violent nature of what happens. A dog that growls should not get as high of a fine as a dog that attacks somebody, and that's the rationale for separating those.
Do you have any more questions?
One more.
Okay.
I think it was Attorney Kitt volunteered to take a run at defining domestic animal for us as well. And in the definition, which is just a one-liner, but it includes dogs and cats, and it says vertebrates, I believe, I'm not looking at it right at this second, includes dogs and cats, but also includes rabbits, birds, and fowl. It says ones that are being kept as pets. I have heard the dog owners and chicken owners expecting that because it's so natural for a dog to try and catch a chicken, that they weren't sure that it was reasonable to charge a dog for attacking a chicken. So I wondered what your thoughts were on that.
Yes, that's been happening for years, and I've often wondered too. But the ordinance says attack on another animal, which is a fowl would be an animal. So we would be enforcing the ordinance in that regard.
Well, we're looking at it now, so it was to define it so it was real clear, and I
Yes.
wondered whether you thought they should be included or not. Certainly dogs and cats or guinea pigs, well,
Because normally dogs are nice as can be to humans when they attack fowl. Fowl's food for them.
right.
That's their food source. So I wouldn't mind at all, lifting that ordinance.
Leaving the fowl
Leave the
out.
fowl out.
What about
Yes.
rabbits?
Rabbits
I don't know
are a
if they get
source of
rabbits as
food.
often.
Every now and then, they'll
Uh-huh.
tear them out of their hutches and attack them and kill them. And they're a source of food also for
Right.
dogs, and that's their nature. So I would leave that out, I believe.
I think one thing to remember on this, though, is we're talking about fowl and rabbits that are being kept as pets, which means in cages on somebody's property, and somebody else's dog comes onto that property, gets into those cages and kills them. And doesn't the victim owner, as the victim owner, wouldn't you want to have some recourse or have the city protecting your property on, your animals on your property?
I've heard both sides of it, is
Right.
the point, and even people, generally with chickens, they're not in a little cage, they're in a pen. And the people whose chickens have been gotten by the dogs weren't happy about it. The dogs were dogs at large in order to get there. And so there's already a ticketable offense if people caught them or figured out who it was. But they, on the other hand, seemed to understand that chickens are food for dogs and that it was just a natural instinct thing. So,
And we're talking about prosecutors using discretion in the charging of these cases. If a chicken gets out and is running loose on the street and gets attacked by a dog that's at large and not tagged, that's a case where as a prosecutor you look at that and say, okay, that's natural prey, this dog was acting on instinct. But a dog that is actually going into somebody else's property, going into enclosures, whether it's just a fence or a coop or whatever, this would allow us to hold the owner responsible for their dog going onto somebody else's property and doing damage or killing animals, that sort of thing.
Are you done, Karen? Or-
that, I wanted to bring that issue out, so certainly that was the last question I had for AC. got
I do
couple
have
for
a
Lou.
comment, though, on what Mr. Kidd said. If the dog doesn't know whether he's trespassing or not, that's the only thing, and he's gonna go after, he's gonna go
Are
after
you
a
sure?
food source, whether it's in somebody's backyard or on the street.
Yeah.
And then if we charge that owner with dangerous dog and he's convicted, we have probably an ordinarily nice dog having to go through the dangerous dog ordinance.
Well, and second shot is,
And
poor word,
euthanized.
second offense is euthanization for eating chickens.
Not necessarily. Under the proposed changes, we're allowing the court to have discretion on second offenses for that very reason.
That's right.
Currently,
Okay.
it would be mandatory destruction, but we want to change that for that very reason.
It's a non-negotiable $250 fine,
Right.
but it's negotiable on the euthanization.
It's the,
And
it'd
the
be the
dog is
court,
also already going to get a dog at large ticket,
right.
right? So how much are those?
Dog at large is $30.
Okay.
Okay, Councilwoman Schwartz.
Well, growing up on a farm and having dogs and chickens, you don't give them a second chance, because usually once they eat a chicken, they're gonna go after chickens again. So, and I would hope we'd have that ability to euthanize after the second offense, I would think after the first offense. But we got an email from Betty Phillips about the Lawrence ordinance, and I had sent an email to you and Lisa that I want to ask the difference between what we're proposing and what the Lawrence ordinance, because we know it's working in Lawrence. And I don't know if they took it from another city in Kansas that has passed these ordinances or not. But Chuck, what's the difference between what we're proposing and what Lawrence has?
I apologize. I saw that you sent that email out around 12:40 today, but I was in a panel discussion at the law school, and
Okay.
and then I went straight into court with Judge Geyer, which
Well,
is
I'm
why
sorry I
we
didn't
were.
give you enough notice.
Right, so I've looked at the Lawrence ordinance, I
Okay.
did when I first made these proposed amendments. I looked at Lawrence and Junction City and Lenexa, Wichita, Sedgwick County has a separate than Wichita. I looked at all of those at the time, but I couldn't speak to that right now off the cuff on what
Okay.
the specific differences is. I do know that Lawrence separates it, they have a dangerous dog portion of their ordinance, but then they also have, I forget how they term it, I think it's like a vicious dog at large. They have different definitions for the different types of aggression, whereas we call everything dangerous dog, even though we have enhanced penalties for the attack. So they separate theirs kind of the same way, they just do it in a different organization, but they do differentiate between an aggressive dog and a dog that actually attacks. And we're doing that in our ordinance. They have the same mandatory destruction portions that we currently have, and that's what I'm trying to get away from, is just to get more discretion based on the circumstances, because every case is going to be different. But other than that, I can't really speak to the specific differences.
Okay, thank you.
Yes, Karen.
I looked at it today, I probably got the same email that you did, and it was cursory, but it looked to me like it had a mandatory, that the person who was sending this in absolutely wants all dogs euthanized immediately. But when I looked at what it was, it had an automatic euthanization, which we've just talked about, but it also provided discretion. It said that the animal control officer may pick up the dog, so it still wasn't automatic, totally, the way theirs was written. I thought maybe, I knew that Chuck had looked at theirs, and it looked like just because of the overall structure of ours, maybe it was about the same.
We could always add shall pick up the dog in certain circumstances, and those certain circumstances could be the extent of the injuries, which would have to be spelled out.
And if
Like
we
what
were to
kind of-
do that, Chuck, what would that do to our ordinance?
Well, procedurally, it could create some difficulties, because if there was a situation where an ACO saw a situation that would require them to pick up the dog, yet the owner wasn't willing to turn that dog over, we're talking about executing a warrant to go in. Municipal court doesn't have the authority to execute a warrant, so we'd be going through district court just to get a warrant to go on property to get the dog, whereas if we just waited until the case is charged and requested that the court order the dog be surrendered, at that point, yes, it takes more time, but then if the person doesn't comply, we do have the ability to put them, or ask the court to put them in jail for contempt for not turning the dog over. So we currently can charge a dangerous dog, even if the dog isn't picked up, and currently we have the ability to ask that the dog be surrendered, and if the court does order that and they don't comply, the person could go to jail for contempt. So we have the ability to do that now. I think if we put in the shall language, that's going to create some procedural difficulties, not only for the ACOs, but for just the police department in general in trying to figure
Prosecution.
out how to do that.
Okay. Thank you. Yes.
One of the things that I noticed in the Lawrence thing was that it said that if they wound, didn't say bite, didn't say scratch, it said if they wound a human, that they are picked up. I'd like to see us really put some teeth in that idea that if I just think it's atrocious that we had some dog maul a little girl, and the dog stayed there. And we didn't pick up the dog because we waited for the owner. I think if it's a dangerous dog, it's a dangerous dog, and we need to do something immediately.
Ma'am, the reason why that happened is because the dog was properly contained, and we would have had to have gotten a warrant to get it, and we knew the owner was home, and we would be able to get a hold of the owner.
I think that the Lawrence says if they wound a human, they are a dangerous dog. I mean, there's no question about it.
That's why time is of the essence. We have to pick up the dog. That's why it should say shall, because we need to go in there and get that dog right away. Because if we did something like Mr. Kidd is saying, the people could say, I got rid of my dog.
Right.
And they really
So if we
didn't,
put
or they
shall
did.
in there, then you feel like that gives us the ability to immediately remove the dog from the premises.
Yes.
I think you're going to run into the same procedural difficulties I was just talking about. And I think we can accomplish this with a policy decision. If the ACOs want a policy that on a dangerous dog, they're going to exercise their discretion and pick it up, I think that's fine, because they have the authority under the ordinance to do that.
Okay. Okay. Thank you.
And I'm concerned with one word changing the whole meaning, and that's why I asked you, Mr. Kidd. Mr. Cohen, good afternoon.
Hi.
Do you have anything you'd like to ask?
No, it's a great conversation.
Okay, we just started. I have some questions, and whoever can jump in. Who deems the dog dangerous? Is that the judge?
Yes.
Okay. We talked about people getting up and moving to another town, and it talked about, I think this was Karen's proposal. If somebody was to move to our town and they had a dangerous dog, would we use documents from other towns or other courts? I know it said municipal court, district court, but what about other courts or I was concerned with that.
Okay. At least during my tenure, that situation's never occurred that I'm aware of. And Chuck, you can jump in if you want. Typically, that would not be something that I would go or have my staff go and search for on their own. That would have to be something that would have to be provided by prosecution.
But if somebody did provide that, would you take that into consideration that that's happened?
If it was permissible under the ordinance, certainly I'd take it into consideration. I simply haven't had that occurrence yet, and I'm trying to think of the language off the top of my head.
Does this
but-
allow for that, Chuck? Because it's saying municipal or district, and it just kind of named those two entities, and I didn't know.
When you're talking about whether a dog has a prior offense, the ordinance specifically defines Topeka City Code. when considering whether it's got a prior offense. So if we learned of an offense that happened outside of our city limits, we could certainly ask the court to take that into their decision on sentencing, because a lot more things are relevant at sentencing than they are for the determination of guilt. But under our code, it wouldn't be an element, and it would be really, really difficult.
But we would
to-
be able to still handle it. He would be able to still use that, right?
He could still
If it was
consider it for
provided.
sentencing.
And the reason why I say that is, I know somebody that had a dog that, the kid was coming in the doorway, he attacked the kid, that was his home. And the insurance company said, we're gonna drop your insurance if you don't get rid of this dog. And so they didn't say you had to put it down, but they said you can give it away. And the owner was gonna give it away, but then he got to thinking, well, he'll probably do it again. Because he jumped up and bit the kid's face pretty good and stuff. So that just led me to believe, how many, there's instances we probably don't even hear about, but there's a lot of stuff like that happens. You know what I'm saying?
And I don't mean to be sarcastic or anything, but it also, when proving the identity of a dog, meaning that it was the same pit bull that attacked somebody 2 years ago in Colorado Springs versus, is this the same dog? We don't have fingerprints, we don't have DNA. Some dogs may get microchipped, and we would be able to prove that in that
And
manner.
I
but-
understand that. I guess I'm just looking at it like, if the, the insurance company said, we've paid out so much medically that you either have to get rid of the dog or we're dropping your insurance, so they got rid of the dog, and if the insurance company said that and they gave that dog away, that dog could potentially do it again.
Right.
No, we might not know about it, but I'm just saying, he just might be a bad dog.
Right, there's a lot of things the court can consider in sentencing,
Okay.
and that would be one of the things that if prosecution was aware of it, we would certainly be bringing it up at sentencing. And the court does have a range of penalties, even on the attack on human, where we're just raising the minimum fine. The court still has a range to go up to 1,000. The court still has the discretion under the proposed amendment on whether to put that animal down if it's a repeat offender, if it caused serious injury. The court still has the ability to put the owner in jail if we think the owner did something above and beyond what we normally see in these cases. So there is still a range for the court to consider, and the court would be allowed to consider something like that for sentencing. It just wouldn't automatically trigger the repeat offender portions
Right.
of it.
Right. Karen?
Along those lines, though, and I asked a question like that last time, and I think the real, with these changes, and help me, both of you, because euthanization can now be ordered on a first offense, the issue of the second offense on a dog that's previously been convicted in Topeka is not as big a deal in
Correct.
terms of making a choice about euthanization, I think. And so with your question, in the definition of dangerous dog, the dog previously determined to being a vicious animal pursuant to city code is sub 4 in that section. Sub 1 is any dog with a known propensity, tendency, or disposition to act, to cause injury, or otherwise threaten the safety of human beings or domestic animals. And it doesn't say how we knew that. So if there was, it was microchipped and,
Right.
people knew for sure or whatever, it would seem that you could use that prior known information. However, as long as it's admissible, and any dog which in a vicious or threatening manner approaches any person in an apparent attack upon the person while on the streets, sidewalks, or any public grounds or places, or in private property other than on the property of the owner. And then third was the dog unprovoked attacks or bites, or has attacked or bitten a human being or a domestic animal. I mean, that pretty much covers the ground in terms of prior behavior if there's documentation somehow, right?
Right. Yeah, the big difference is going to be in subsection E, where it talks about a dangerous dog at large, because a dangerous dog at large is a dog that's previously been found under Topeka code to be dangerous, and then if it's found at large, there's enhanced penalties. It's no longer just a dog at large, it's a dangerous dog at large. And so we wouldn't be able to consider outside jurisdiction stuff for that.
Even though it says dangerous dogs shall mean any of the following?
Subsection E reads, any dog that's been found to be dangerous or vicious under Topeka City Code.
Okay, okay.
And so it is specific to our code
Okay.
for that. And that would be, the only area where this really would be a deterrent, if we knew a dog was dangerous in another jurisdiction and then came into the city.
Because I know, like, a lot of pit bull owners, you know, they live outside the city limits, you know.
Right.
And, you know, I know that we have put in place that they be microchipped and all that and insured and all that. But it's just a couple things. It's just, I thought we had all this from 2 years ago, so everything's swinging in my head now. Okay, is there anything else you want to add, Chuck? Or your team there?
I don't believe there's anything,
You were supposed to define, according to the notes, define great bodily harm. Did you do that yet?
oh, no, I
about
believe
that
that was something the court does.
Oh, okay.
The court does that. We would ask the court for that interpretation. That's a question of fact for the court to determine. Previously, we discussed this, and that language, great bodily harm, comes from felony statutes, the difference between battery and aggravated battery being great bodily harm. And our Supreme Court has actually defined great bodily harm as, don't quote me on this, but it's something more than mere bruising. But there's some language that gives the court guidance when making that fact-finding decision on whether great bodily harm has occurred. And that's consistently been left for the court to define, so we didn't really want to define it here
Okay.
in this.
And then also, I had also made a note of the definition of domestic animals.
We did include that we changed 6.05.010, the definition ordinance. Before, we were just looking at changing the dangerous dog ordinance, but we did go ahead and propose amendments to the definitions where we tweaked the exceptions and the affirmative defenses and kind of molded them all into one definition that'll be consistently applied. And we also added the domestic animal definition there, and that's what we were talking about, that it includes fowl and rabbits.
You want to read that?
I'm sorry, what?
Would you read that for
The,
the viewers, please?
yes, domestic animal means any vertebrate animal that is kept as a pet. Domestic animal includes but is not limited to dogs, cats, rabbits, birds, and domestic fowl.
And that starts on line 64, correct?
Yeah, 64 through 66, yes.
I did like the part where they're able to either leave them in the humane shelter or the vet of their choice, and you said that has to be in the Shawnee County.
Yes, the city one.
And why did we do that?
I'm not sure why that happened, maybe because of the transportation, that they have to go clear out there and might not be able to keep up on where it's at, that might have been something.
Does staff know why that's like that?
This was part of
That's
the
not new.
original.
That's not new.
It's not new this round.
Right.
It was done before, and I think she's right. It's something that I learned when we met last time was that notwithstanding the requirement that it be held at Helping Hands or the vet of the choice, which when we did that, it was mostly to help people save money, because sometimes their vet wouldn't charge them. You know, we were wanting to get rid of high bills, and at that time, isolation cells at Helping Hands. And also because sometimes people couldn't pay, just the drain on the city budget for holding all these animals at Helping Hands all the time. So we put the option in to have if they had a veterinarian who would keep the animal instead, that was okay, thinking they could negotiate fees a little better. We didn't want it to kill people financially just because their dog had to be held. We learned from Chuck that the people could petition the court for permission to take the dog home. And so.
But it's at the court's discretion, correct?
Right.
Yes.
Okay.
But that made it an option to, based on being able to convince the court to not have those expenses at all while it was pending a decision. So.
Well, I like that because I think, I've had people that have called me and said they've their dog's gotten diseases or kennel cough and, you
Right.
know, and of course
Yeah.
they feel their vet, you know, a little bit more cleaner. The vet knows them, blah, blah,
Right.
blah, you know.
Mhm.
It's good to give them that option, but most people don't take it. They just let us have the animal come down at the shelter.
Okay. Councilwoman, anything?
There's two things I'd like to see happen with all of this dangerous dog thing. That, one, we pick them up if they've intentionally wounded a human. The dog has no choice but to be picked up. And number two, that the dog owner covers the cost of whatever the wound, whatever happened with the cost of, you know, injury. And from what I'm hearing, I don't think we require that.
The prosecutor's office currently seeks restitution on all verifiable medical or vet bills from injuries like this.
Okay.
So we do ask for it, and we've been successful in having the court order restitution.
So in
on
other
these.
words, if we say, well, we'll just charge them $30, hoping that, you know, that instead of the $250, that they'll pay for the vet bills. We do see that they pay for the injury that was caused by the animal. And we have a German Shepherd. I mean, if our German Shepherd, she's 11 now, but if she had ever hurt anybody, I know we would have covered the cost of that damage. And, you know, if she really had wounded, we would have wanted her to put down. You don't keep a dangerous dog. They don't, once, you know, I grew up on a farm. Once they taste blood, it's true. It's hard to train them not to. And I love dogs and cats and all kinds of animals. So those are the two things I'd like to see that we end up with in this whole process. That we hold animal owners responsible if they cause injury, and that, you know, we pick them up as soon as they do cause injury. So that's my 2 cents.
Well, I think we try our best to hold them accountable, you know, animal owners accountable, but unfortunately, there's those that sometimes when their dogs mess up, they just let the shelter have them because they can't afford them, or
Then we put
or
them
they're
down.
scared, yeah.
They're a
So then the
dangerous dog,
cost-
then we
yeah.
put them
Well,
down.
no, not necessarily.
The irresponsible dog owners out there, that's who we see that have
Mhm.
dangerous dogs.
Yeah,
They cannot afford to pay a fine, cannot afford vet fee, shelter fee.
And-
Those are the type of people that we run into.
And so
we-
for the most part, does that work then? People that leave the dogs should have,
That leave the dogs,
that don't pick them up?
that don't pick them up. If we serve the ticket, then the animal stays at the shelter until it's released back to them.
Right.
If we just pick them up running at large and they're dangerous, we put the dangerous dog ticket on, pound them at the shelter, sorry about that. And pound them at the shelter, and sometimes they do not claim the dog, so the ticket never gets served and the dog gets euthanized. Did that answer your question?
I think so. Now, what Deb Malik, I hope I'm pronouncing her last name right. Malik explained to me is that if a dog doesn't get picked up, they do a behavioral assessment on them. And if they fail the behavioral assessment, they're euthanized. But if they pass it, then they will release them for adoption. That just because the incident happened here, they will generally release them to another community rather than have them picked up here.
A rescue
not-
group, perhaps?
Correct? Now, is that not correct?
That is correct.
Okay.
They do behavioral assessments there.
Right.
To see if the dog will be well behaved with another person
Exactly,
after they get the dangerous dog ticket.
right.
Um,
I just wanted them to know they aren't automatically put down just if they're abandoned, that if
Right.
they're released
As far as I
to
know,
the
that's how they
shelter.
operate out there, yes.
She said that they then assess them and make the decision themselves. Okay.
so we never know.
I have one more question
Sure.
about the exceptions. The sections that Chuck was just going through in the, where we've cleaned up, if you will, synchronized the definitions for the exceptions for a dangerous dog that injured a person and one that injured an animal. this is really very technical, I think. The language I felt was awkward in the use of may. I think it was intended that what it says right now is notwithstanding the definition of a dangerous dog above, no dog may be declared dangerous if an injury was sustained by a person, I found that hard to track, and there's similar language about when a dog attacks an animal. I wondered if the language instead, if it read, notwithstanding the definition of dangerous dog above, an exception may be granted if injury or was sustained, and so on. And the judge is here too. I just wanted to make sure it was clear that the exception might be granted, but wasn't automatically going to be granted. That the prosecution would look at the case and the court would look at the case, and you all would decide whether an exception would be granted. I mean, a dog might do something on their own yard, but if there were other circumstances such that that shouldn't mean that that dog wasn't declared a dangerous dog. Do you follow me? Okay. I just wanted to make sure that the way it was phrased said that an exception may be granted, meaning that it was optional.
Well, I mean, as a homeowner, if my dog's in my backyard and somebody, as an example, trespasses in my backyard, I don't want any daylight there for my dog to be declared dangerous if it attacks that person, and I think that's why it's written this way. If somebody trespasses or is committing a crime on my property or attacking my family or my animals, and my dog is defending itself, my other pets, my family, or my property, then as a homeowner, I want to feel secure that my dog's not going to be declared dangerous, and I think that's why we wrote it this way.
There are, I mean, I see both sides of it because I hear from the animal advocates, but I also hear from the people that are worried about dogs biting anybody from the mailman and
Well,
the
the
meter reader.
But those
to-
people are not trespassing or committing a crime.
I know, but they're not trespassing or committing a crime, but they are on that property. And if the dog has, you know, one of the stories I got told was the dog that, I think I shared it last time, who apparently would always bite mailmen and meter readers because there was a mailman who always sprayed that dog with mace when they came. And so it had made the dog vicious by that behavior. But if you have a dog that's vicious anyway, and you just happen to be the meter reader on the property and that dog bites, you know, the history of that dog and why that dog had that behavior, aside from just being on its property, we also had the example of people walking their dogs, where it's going to be a judgment call whether that dog was just aggressive and bit the other dog or bit the person who was walking the dog going the other direction, or whether that dog was, to all intents and purposes, the dog thought it was defending its owner against harm's way, and then an exception should be granted. It seemed like each of those cases might be different. I mean, I understand your feelings about your yard, but it might be that your dog was vicious.
But it could be a friendly dog that turns mean
Exactly.
and bites somebody coming onto the property. And then you have a friendly dog that's being convicted of dangerous dog. That's what we're trying to.
Well, so
that's
for me, exactly, it should say that an exception may be granted, so that given that history of that dog, if that dog bit somebody, it would probably be granted. But if the dog had a history of threatening the neighbor's kids through the fence, and people, and being, you know, maybe nipping even at the kids in the family or whatever, then maybe the exception wouldn't be granted if they bit the meter reader or whatever. That was my point, that people have talked about so many different circumstances that might be the history of the dog itself, as well as the situation that might exist in the actual incident. whereas we've been making it optional on those other things, it seemed like the exception should be up to the court as well.
Well, I think if you have two people walking their dogs, passing each other on a sidewalk, and those dogs start showing aggression towards each other, I think a prosecutor could look at that and say, the dogs provoked each other, and therefore we're not gonna declare either one of them dangerous. If they're both kind of instigating the incident, they're provoking each other.
Correct.
So right now, we don't have to find that dog dangerous, so we do have the ability to use discretion when we look at this. And I think that's the example I heard that you were concerned about, is if people are out walking their dogs and a dog's approaching, that dog may feel as if its owner's in danger and therefore become aggressive, the other dog doing the same thing. Those dogs are provoking each other. We wouldn't necessarily ask that either one be found dangerous if that's what the circumstances called for.
But when you make the investigation, you have to ask which one provoked the other, or which one attacked first.
Right.
Maybe the bigger dog got the little dog, and now the little dog has to go to the vet. So then the big dog could be charged with dangerous dog.
Well, it's good conversation. I think we need to fix the language either way. If we mean for it to be optional, I think we need to clarify how we say may. If your intent is that that an exception shall be granted, then we should say shall instead of may, and clean it up that way. I think the language that's there is a little awkward. So your intent was that it would mean shall, that the exception would always be granted in those circumstances that are listed?
Right, and I apologize, I'm not an English major, but I think if we were saying that the dog shall be deemed dangerous or the dog may be deemed dangerous, I think there's a distinction there.
Absolutely.
But where we're saying no dog may be declared dangerous if these exceptions apply, I don't see the same distinction between may and shall in that situation. But again, I did not study English.
I see what you're
so-
saying. You know, and maybe it does cover it, you know, the average person needs to be able to read that and track
Right.
it. And so I certainly had my stuff wordsmithed many, many times. And so it's nothing personal on my part. I wasn't sure I came up with anything better. Just was hard to read, and I think we need to have it real clearly say what the intent is.
Mary, I see you studying this.
Well, I am an English major,
Uh-oh.
and I drafted this language.
All right, there you go.
I think it's very clear. I mean, I've been drafting legislation for 25 years, and so I think this is very clear.
12 of my years, I know. That's why I see, she threw them glasses on Karen, woo. Like, watch out.
No dog is going to be declared dangerous if these conditions apply. I think it's very clear, and this language needs to guide the attorneys and the judge.
Can you give her the mic? I'm sorry.
If a person who's not an attorney or a judge has a question, they can certainly inquire, but this language is written for lawyers and judges.
I would respectfully disagree on that, having worked on these things for about the same number of times. It's so important that that the average person and the neighbor who's worried about it or whoever can get on the city's website or can read that and can understand whether it's a shall or a may. I really, if there's a way we can do both.
Well,
I think
I disagree
shall or
with
may.
you, but
Okay.
Well, the only thing is, working in legal, I know one word can change the whole meaning, Karen.
I
And
know.
if that's what I'm hearing from legal, is that correct? Correct me if I'm wrong, is if we put in shall, that'll change the whole meaning. Is that correct?
Well, that's what I was saying. If it was worded that the dog shall be or the dog may be, yes, that word changes everything.
And that's the thing, I've learned that in legal, working in
Right.
15 years in that. So I will respect staff with that, and we're just gonna have to get our constituents to understand. Judge, do you understand this? Am I correct? Is this good for you?
Yeah. You know, I need to be very careful.
I understand.
Under my role.
I understand.
I'm going to enforce and interpret anything that you
You're
pass.
right, and I shouldn't have said that. Luther, what about you over there? Now, you didn't throw your glasses on, and you're not a major, so. I think this is the best that we could probably get it, Karen.
You know, laws are for people, and I just want to make sure with
Right.
the same intent and the same legal standing, if there's a way to just build the words so that everybody's clear on it the first time they read it, I think it always helps.
Luther,
I don't have anything to add.
okay?
Nothing past what Mary's already said.
And I forgot your name.
Jason.
Jason? Russell?
I have nothing to add.
You don't have any majors here, boy. Okay. Is that all? Karen, you have anything else?
The only other thing I had, I would like to run this by Helping Hands before, I don't know if you're going to want to vote it out today, you certainly can, but they're the ones who are our agent, and they deal with both the legal and the practical on it, as the ACOs do, and I would sure like to give them the opportunity to give us some feedback. Then overall, wanted to hear how the judge, you were reported to think that this would work well. You know, the driver from Chuck's point of view was to make this more consistent and fair and successful for the owners as well as the animals in the courtroom. And so I certainly wanted to hear from you directly whether you thought we were still missing anything or whether this would make it better.
No, again, and I'm covering myself here. Yeah, I'm going to interpret and enforce anything that you pass. I can tell you, without talking about any specific case, I think the changes that have been brought forth are probably beneficial to the public and bring clarity, I think, to the public as a whole. And generally speaking, anytime I get more discretion, which I think this gives me, and potentially gives more discretion to the prosecution, I may be biased, I think that's a good thing, because especially with animal cases, and I think any of the attorneys and law enforcement that are here would tell you that, boy, no two cases are alike.
That's right.
There are so many different factors that come in. So in that respect, I think the clarity and the added discretion, we can apply the law to each unique circumstance, and that's a good thing.
That's good. I appreciate the team right now, and so any comments and questions I had, don't get me wrong. When we walked into this the last time, nobody trusted anybody. They weren't happy with the court's decisions and use of discretion or the animal control officers, and they were all hung up at legal. So this is so much better. So if the discretion at this juncture is going to work, that I think is great.
Well, I would like for this to come out of committee, and I'd like to see a vote, so we can continue on. I think we've had 2 meetings, Karen. I know you want to take that to Helping Hands, and you're welcome to do that, because this does come back to the council, but I'd like for us to I'd like for this to come out of committee so we can get it back on the agenda, either as pass, do not pass, or what was the other one, Mary? Pass, do not pass, or
Pass as amended.
pass as amended. So I would take something from the floor. Schwartz, Councilwoman Schwartz.
Make a motion to pass it out of committee
Pass
as
it.
is proposed.
Pass, would that be pass as amended, or just
As proposed.
as proposed? Okay, okay.
Yep, I'll second.
Okay, it's been moved and seconded. All in favor, raise your right hand. Okay, it's 3-0. At this time, I'd like to ask, like to thank staff for answering all of our questions, working really, really hard. Ms. Pinkley, thank you for coming again. We value your input. We value your profession in this. We really do, because you're out there with these vicious dogs. So we do. We look to you. So if we can get this out of committee and back on the agenda. I know that we have something else regarding the guards, the merchant guards. Angela, if you could start working on setting that up, that would be great. Is there anything else before this committee? Any comments, questions? We'd like to thank everybody for coming. Thank you. This ends our meeting.
Thank you.